когда вот бываешь
When you go to, at some age, at some point in your life, you make some conclusions for yourself, or you even discover some insights. After you come to Zmeyova, and I was there with Henry Reznik, the famous Russian attorney at law, and Mr. Reznik spoke about it in public. The fact that we live is a miracle. It's quite accidental. And the fact that we survive is an absolute whim of fate. And secondly, what is directly related to the topic of our seminar and my presentation, the second insight is about this destructive force which makes the law its opposite, whereby the law becomes the antithesis of the law. And because we understand that the perpetrators of the Holocaust were acting in direct conformity with the laws of the Reich, of the Third Reich, and the Nuremberg laws, the Wannsee Conference, all of these laws, acts were put in action. This was the source of legality in Hitler's Reich, and people were acting as I said, in accordance with the laws adopted by the seemingly legitimate bodies of power, the legislature. So this needs to be always remembered. That being said, we continue to maintain one of the most important civilizational values, and how is this possible to combine the two? Something that may become a preparation for this lecture. So today, if I go back to our Russian realities, and not just to Russian realities, but something that deals with our neighbors too, there is an empirical understanding that freedom and the law are antipodes. Because what is related to the law, to the concept of the law? I mean, the law is a limitation on freedom, something that needs to be feared. And in practice, this may be the case. But what do we understand as the law? The law is everything that has some sort of a judicial form. A rule, a regulation, a piece of paper with the name of the law written on it, some commentary by the court, some legal counsel, or let us say a verdict of the court judgment. So some sort of a legal form. And today the official position of the state and the propaganda too say exactly that. This is the written codified law. This is what the court said, then this is the law. But if we try to go a bit further and try to make another little step, or try to use our spade a bit deeper, then how much of what we're reading is really related to the jus naturalis? So then the law is perceived as an antipode of freedom. And the reason why this happens is that the form is predominant over the content. The Russian legislation in the past several years is becoming repressive, which is often dominant over other practices of legal norms, such as the freedom of choice, and these instruments become the main means of the law. However, these unsubstantiated or demagogical repressive measures, the expansion of this repressive machine, have acquired such a scale that we're reminded of one other formula, which is the banality of evil, introduced by Hannah Arendt, which is indeed yet another aspect of what we're seeing today. So we stop being surprised at what is happening, and unfortunately we take this as an order of events. So it becomes clearer and clearer why the law and the freedom are so often opposed. By the way, incidentally, the fact that my lecture is between these two lectures, you'll see the name, which is the human rights and the rule of law. And in the Russian version of the program, you'll see civil society and the law. No, I don't mind. I don't mind. I don't object, because it's easy for me to maneuver this way between these Silas and Charybdis of the two programs, the Russian version and the English version. Thank you. This is a very valuable addition. So we are in different dimensions. So, to make these ideas agree, to bring them into agreement, we may better understand what kind of crisis we're facing. There was this man, a lawyer, Ernst Rabel, who was a German jurist. I learned about him from my great teacher, academician Sergei Alexeyev. Ernst Rabel was one of the first comparative jurists in the legal tradition, and he, being this comparative jurist, introduced the notion of the right of civilized nations, whereby he implied a certain global phenomenon which was overall related to the Western civilization. He showed that the law is a living organism which may have some specificities in different countries, but it has the basic common traits. And these basic common traits are in the basis of progress of the entire mankind, such as the right of the civilized nations. What is the purpose of such right? Clearly, this is not punishment and not a repression. And this is important to understand, because repression is an ancillary function which is only called to protect the positive rights, to protect them from infringement. And there is no other function of punishment. And this restrictive nature of punishment is set in the very essence of the criminal law, whereby the common law, the private law, is about everybody of us. It's about individuals, it's about personalities, and it's about making choices and bearing responsibility for these choices. How we realize or implement or fulfill these inalienable rights in our private lives. It's the right on property, the right for entrepreneurial or some other legal activity which is not conflicting with the law. It's the right for free occupation. It's the right to gather information freely, to speak freely, to create families. The right for childhood. Decent childhood and the protection of health. But so this is a conglomerate, the fabric, the tissue of our lives. And so these values are all to be protected from infringement by such branches of the law as the criminal law and the administrative law. Such is the main balance between the principal and the subsidiary law. But, of course, these basic principles and values, and let me just repeat this one more time, that these are individual rights, they're regulated by the civil law. And if this system of priorities is out of balance, is out of the order, then the very value of the law gets corrupted. And we can see that starting from the 18th century documents, the French Declaration of the Rights of Man and Citizen, the American Declaration, all humans are equal and given by the Creator, by our Creator, for the right to aspire for happiness. And as that has been mandated by the Russian law. So the right of the civilized nations has three main characteristics which describe them as a guarantor of the human freedom, individual freedom. The first is the humanistic nature. So in the basis of the law, it is not the Tsar, the police, the army, but man, a human being. And this is what the very first lines of the effective Russian constitution, to which your humble servant also participated as a member of the Constitutional Assembly of the Russian Federation in those years. So the humanistic nature of this law, the right and the mandate to protect his or her freedoms. And secondly, this second pillar is the role that is played by the law in everyday life by performing the function of global regulator. In this sense, the human community has not come up with any alternative to the law, and frankly, I do not see any possibility for such an alternative to emerge in any foreseeable future. And I think that there is no such alternative. So, and the third pillar, which in totality make up this concept of the laws of the civilized nations, are the so-called legal technologies, the norms, the concept of legality, the institutions, which are more or less similar in the so-called civilized nations. And the issues related to property regulation will hardly be any different, be it in America, Germany, France, Russia, or Georgia. The same pertains to other fundamental rights and freedoms. Two other important statements. The foundations. The first is the freedom of choice. Freedom of choice, which means something that that I want or desire or will is the subject of negotiations with my counterparties. Any interaction you can analyze the most primitive interaction as you switch on the electricity. You are availing of communal services, of electric energy that you have to pay for. And at every step, we are entering certain agreements by either joining the commonality of such agreements or else developing our own individual agreements. So at every point in time, when we enter such interaction, we make a choice. So it's the freedom of will or this dispositionary nature of the law. The second is the presumption of goodwill. The presumption of goodwill, which presupposes the freedom, that freedom is granted to us, that we act out of goodwill when performing our rights. The goodwill presupposes an absence of evil intent. We do not have an interest, intent, or desire to damage, to inflict damage upon others. And if the opposite has been proven, whereby we're shown to have abused of our rights, or that we have been shown to contradict, conflict, or impinge upon the rights and the interests of the others, then there are two egresses. If we do not violate the law, then we are not entitled for legal defense. And if, that being said, we violate the law, then there is the question about litigation.
Then this is a question of law and punishment. Again, this goes in line with the public law and its rules, which seek to defend our rights and freedoms from being breached by somebody else, be it administrative or criminal law. For that matter, this is the responsibility for crimes against public safety and against the state, because society and institutions of the state are needed. And they're exactly needed to realize human rights and freedoms. Because if you breach them and if you block their action, each of us will be affected in this context. What do we need to ensure so that the right of civilized peoples should not be only declarative but a true regulator of public relations? That's a bit, I would say, quite little. But it's so much easier to formulate it rather than enforce it. This is particularly important when the main source of law is written law. This is continental law, which is widely adopted in Russia and other continental countries. This is exactly what is known as culture of law. We should have culture of the law, which means that law should not contradict the principles and the basis of the law, which I just described to you straight away, and the basic posits of the Constitution. What follows is that if a law, whatever law, maybe even if it is adopted by Parliament, is not in line with the basic then it is an illegitimate law. That seems like a contradiction in terms, but it isn't. illegitimate laws, exactly the laws which I quoted at the very beginning, Nuremberg laws in Germany, the laws adopted in the Soviet Union that allowed for torture, allowed for quasi-court and out-of-court executions, and foreign agents, the same to their illegitimate laws for this exact criteria. So this should not be used where the law of civilized nations works, should not be adopted and should not be used, implemented. And secondly, the law should be formulated in such a clear manner so that it should avoid all kinds of ambiguous implementation, should have no gaps, that as material posits that would be missed, and it should not contradict other laws in place. It should be in harmony with them. And certainly the law should be published, because they can't be held accountable for the unpublished law in accordance with the general accepted procedure. In all, this is what my teacher, regrettably Mr. Alexeyev, who passed away several years ago, he said: the culture of law may exist only in a favorable and enabling social milieu. It is non-existent elsewhere, it is being destroyed, and instead of growth and development of the culture of law, what happens is what Sergei Sergeyevich used to call the collapse or the crush of law. This is something that we in our everyday language call legal nihilism. But this is something pretty superficial, but then this crack up or the collapse of law is a better term. What does it mean? If I speak about it, it means that law, if the social environmental milieu is not favorable, it turns into its opposite. In other words, arbitrary action. What does it look like? May I quote Sergei Alexeyev, and you may well compare. Do you find any things about things that are similar or not? That is your free choice. The substitution of the right of the government, which is typical of authoritarian regimes in its varieties, law and courts may acquire and do acquire reactionary anti-legal nature. Law very often becomes a medium of grand power arbitrariness, sometimes covered by well-looking laws. Independent court becomes part, independent court of course in quotation marks, is part of the authoritarian government machine, where the form and prestige of an independent court open up ostensibly legitimate space for implementation of arbitrary rulings by the government, by the ruling government. I'll give you, open up. This is food for thought. But so far we continue. In all the countries, so this collapse of law, Sergei Alexeyev, and I call it, he thought that was the main reason for major social and economic and other mishaps, and thus the main danger. In every country, not in every country where it's mostly court precedent instead of written law, the prerequisite for the functioning of the law of civilized nation, for the efficacy of law enforcement systems, is certainly execution of justice. Because if there is written law, even if that law, if it is legitimate, it does not contradict any fundamental legal rules, it still is characterized exclusively through court procedures, at least any time when there are disputes or collisions, or through other law enforcement decisions or bylaws that are taken, say, by the executive government. And if there is an honest and impartial court, like an independent branch of government, and where this court serves like an impartial arbiter that can return judgment for these two parties at conflict, whatever they be, the state or an individual person or legal entity. It means there is justice in the country and there is law, this law of civilized nations. If this court is non-existent, no matter how good are the laws, neither the law nor implementation of justice cannot exist. And we should point out that all the courts matter, anything from Supreme Court to the to the Justice of Peace, because each of them their own unique, exclusive competence, and nobody can stand in their way. And in order for the court to be independent, impartial, and honest, we need adversarial nature of the two parties, and each person that does not have to be the pundit in law can have the right to seek professional legal help that should be accessible and effective. This last point, this is the meaning of the institution of, again in English that would be the word barristers, but in Russian and continental law it would be lawyers, like advocates, because in this sense advocates bar is the only non-governmental institution that not only is entitled but also has the right to oppose the state in their professional dealings. This is exactly the institution where I have the honor to belong to, that at all times under any government has been for that government an evil for this particular reason, because no government likes its opponents, even the most democratic governments. But the degree of tolerance to this evil has been different, and in this country, in Russia, this has always been, it has varied. Now I would put it very minor, I would put it this way, but there are other situations, for example in China, where advocates at this time, I wouldn't want to use the word in packs when I speak about human beings, but I would say class arrests, group arrests, and where they serve many years in prison. To those advocates who serve like defenders for dissidents, for those who oppose the government, who take part in political cases. The same is now just taking the first steps in Tajikistan. In our beloved native Russia, things are not quite well about defending professional rights of advocates and the risks of this activity. I'd stop at that. Thank you for your attention. Let's start the Q&A.